Chapter 13, The Juvenile Court. Introduction. The greatest differences between the criminal justice system and the juvenile justice system are apparent in the juvenile court. The structure of the juvenile court varies widely. In some populous jurisdictions, they're part of the juvenile justice center. Elsewhere, they're a specialized court that operates in a central courthouse. Juvenile courts, family courts, or magistrate courts are examples. Organization and jurisdiction. Juvenile courts are almost exclusively a state and county responsibility. The federal government defers to the states on juvenile offending. The juvenile court is fragmented. The key players in the juvenile court system represent varying interests, but most must work together to achieve the goals of ensuring justice, providing the best interest of juveniles, and moving a high volume of cases. Juveniles. Females represent only a small proportion of the delinquency caseload. White juveniles comprise 65% of the cases, and 33% involve black juveniles, 1% Asian, and 1% American Indian. Juveniles younger than 16 at the time of the referral accounted for 54% of all cases. Juvenile court judge has discretion in conducting the court's business, ensures that juveniles receive due process, rules on pretrial motions that challenge the circumstances of the arrest, interrogation, and search and seizure. The judge also decides if the juvenile will be kept in custody during case processing or returned to the parents. He approves plea bargaining arrangements as well as trials or hearings and the juvenile's culpability, decides on the disposition, and protects the juvenile's best interest. The prosecutor. After the due process revolution of the 1960s, the prosecutor became part of the juvenile court system, represents the state's interest in hearings, and decides if there's enough evidence to proceed or if the case should be diverted. The Juvenile Defense Counsel, in a series of Supreme Court cases, due process protectors concerning standards of proof and the right to confront hostile witnesses required by juveniles to be represented by competent counsel. Public defenders are state employees who represent the interest of those who can't afford private counsel. Private, court-appointed lawyers work under many of the same constraints as public defenders. Juvenile intake officers. They recommend to the judge whether the case should be moved to the juvenile justice system. More than half of the cases are dismissed or diverted to other agencies at the intake stage. Must consider the juvenile's personal safety, risk of flight, and the risk to the public if the juvenile is released. Juvenile probation officers have two roles. They craft supervised treatment plans for those juveniles placed on probation and act as an officer of the court by investigating juvenile backgrounds and making recommendations to the judge on the appropriate disposition. The juvenile court process is slightly different from jurisdiction to jurisdiction. Essentially, the same functions are accomplished as the cases move through the system. Custody and detention. Taking a juvenile into custody is the equivalent of arresting an adult. Juveniles, but not all adults, may be taken into custody for their own protection in cases of abuse, neglect, or dependency. Once in custody, the juvenile is subject to being held in detention until the intake officer and the juvenile court judge can evaluate the case. Petitions and summons. A petition is the filing of charges against a juvenile. May be filed to protect a child from harm if the parents are abusive or absent. A number of people, including police officers, teachers, parents, or nurses and doctors, may bring petitions to the court. Once a petition is filed, a hearing date is set and summons are issued. Juvenile court hearings. The juvenile court has three types of hearings: preliminary, adjudicatory, and dispositional. Each state has its own rules on how these hearings are conducted. Preliminary hearings are the initial pre-adjudicatory hearing in which the judge explores the nature of the case and decides if it should be processed further. The judge might appoint a guardian ad litem to represent the juvenile's interest where there is conflict with the parents or the parents aren't available. Adjudicatory hearing is similar to a criminal trial but without a jury. Juries are used only in rare cases. Guilt and innocence aren't as important. The judge may craft solutions that are in the best interest of the juvenile and society, regardless of what happens in the hearing. Juvenile court proceedings. For status offenses, the judge will look for a preponderance of the evidence. In cases in which the juvenile is accused of offense that would be considered a criminal offense for an adult, the standard of proof is beyond a reasonable doubt. The predispositional report represents two types of information: legal, which includes circumstances of the case, presence of co-defendants, victim input, aggravating or mitigating circumstances, and review of past delinquency. Social history and present circumstances include parents, siblings, educational successes and failure, alcohol or drug use, mental health issues, or housing situations. The dispositional hearing, when the juvenile court specifies what should be done, is designed to help the juvenile even if incarceration is involved. A jury trial. The juvenile due process rights are enhanced by the procedures. Plea bargaining occurs at 2 points. Intake. The intake officer can reduce the charges or divert the case. At the adjudication or disposition, defense lawyers will attempt to strike a deal to reduce the charges and avoid any negative stigma. Due process. The due process model results in often contentious adversarial proceedings in which the judge sits as the neutral party while lawyers battle to win the case. Juvenile enjoys due process rights comparable to adults only in adjudicatory proceedings. Juveniles have 4 constitutional rights, and curtailment of their freedom is possible, including the right to a lawyer, the protection against self-incrimination, the right to notice of charges, and the right to confront and cross-examine witnesses. A juvenile waiver exposes the youth to more severe sanctions but allows the full range of constitutional rights. 4 issues must be decided in order for a waive of the case: age, seriousness of the offense, probable cause, and amendability to treatment. There's 4 types of blended sentencing: juvenile exclusive, juvenile inclusive, juvenile contiguous, criminal exclusive, and criminal inclusive. Who gets waived? There is considerable variation across jurisdiction in the pattern of who gets waived to the adult criminal court system. Statutory exclusion: all offenses that meet certain conditions will be heard by the criminal court regardless of the defendant's age. Sometimes cases waived to the criminal court receive less severe sanctions than if they had been heard within the juvenile court system. That concludes this narrated PowerPoint presentation.